Welcome to Direct U.S. Immigration's channel, where you get direct access to our most up-to-date immigration and global mobility space. My name is Maitreya Brown, and I'm going to talk about the EB-1A frequently asked questions. You're not going to want to miss out on this one. Stay tuned. Thanks for tuning in. My name is Maitreya Brown, and I'm a U.S. immigration attorney based in Washington, D.C. I'm also the principal attorney at Direct U.S. Immigration, where we work with clients in all 50 states and around the world. Before we start, click on the like and subscribe button to follow our Immigration Hub to get the latest immigration information that could be vital to your case. And also, be sure to stick around until the end to get bonus tips about notes regarding letters of endorsement for your EB-1A petition. So what's an EB-1A green card? So this highly prestigious immigrant visa is reserved for only the most extraordinary individuals in the sciences, arts, education, business, or athletics, and carries many benefits. So if you're curious about what qualifications are required for this process, keep listening. So who qualifies for an EB-1A green card? So the EB-1A is reserved for individuals who have achieved extraordinary business, education, science, art, and athletics achievements through sustained national or international acclaim. So qualified applicants are at the very top of their field and are widely known within the industry. The work being done must also be able to impact the U.S. positively. So how does USCIS define extraordinary? So an extraordinary individual is an individual who has risen to the top percentage of people in their field. You can prove this by providing evidence of nationally or internationally recognized prizes or awards for excellence, membership in associations in the field which demands outstanding achievement in its members, published material about your professional or major trade publications or other major media, your original contributions of major significance to the field, your review of others' works as a judge, either individually or on a panel, authorship of scholarly articles, performance as a leading or critical role in a distinguished organization, evidence that you command a high salary or other significant high remuneration in relation to others in the field, and anything else that shows you have risen to the level of extraordinary achievement in your field so that you are considered an extraordinary individual. Another frequently asked question is, do I have to be physically present in the U.S. to petition for this green card? And the answer is no. So no, you do not need to be in the U.S. petition. In fact, many EB-1A petitions are from individuals who are actually overseas, and if you are abroad, you must go through consular processing. Now, if you are inside the U.S. and in lawful status at the time of filing, you generally can adjust your status to a green card holder without exiting the U.S. Another question is, do I have to work in my field? And yes. So you must show that you intend to work in the field through which you have attained your extraordinary ability. Another question is, who is the petitioner in an EB-1A case? So one of the main benefits of the EB-1A green card is that you can self-petition. So that means that you do not have to have a job offer, and only a few green cards allow the beneficiary to self-petition, including the EB-5 for investors and the EB-2 with the national interest waiver. Another frequently asked question is, do I need a job offer or a perm labor certification? Unfortunately, you are not required to have a job offer from a U.S. employer because, as I said before, you can self-petition. So subsequently, you do not need to go through the perm labor certification process. If you choose to have a sponsoring employer, that employer will still not be required to acquire a perm labor cert. Another question is, how long does an EB-1A green card last? So employment-based green cards are valid for 10 years. And at the end of that period, you must apply to renew your green card, which is a pretty straightforward step. The only caveat around employment-based green cards that are issued for 10 years are investment-based green cards, and those, like for example the EB-5, those are typically provided for 2 years. It's a conditional green card, and then you can then remove those conditions prior to those 2 years expiring, and then you can then get that 10-year green card. Another big question we get is, which forms are necessary for the EB-1A? So the primary document you will need is the I-140 petition, which can be found on the USCIS website. And when your petition is approved and your priority date is current, you must file the I-45 application to adjust your status to legal permanent resident if you are currently in the U.S. And in addition to that form, it is also recommended to apply for a work permit and a travel document, so that I-765 and I-131. But if you are abroad, you must complete the DS-260 online immigrant visa application. Another question is, can I use premium processing? And the answer is yes, you can. So the EB-1A Premium Processing Service is a feature USCIS offers to expedite that form I-140 processing time, where you can have your I-140 processed within 15 calendar days. And in order to file for premium processing, you will need to file Form I-907, which is that request for premium processing service. And you can either file this concurrently with the I-140 filing, or you can file that I-140 case, and then while it's pending, and of course after you've received that receipt notice, you can then upgrade it to premium processing. Now, is premium processing available for all green cards? And the answer is no. So premium processing is unavailable for a lot of green cards actually, so it is generally good to utilize it if you have that option, and of course depending on your unique circumstances. Another question is, will the EB-1A Premium Processing increase my chances of approval? And the answer is no. So it is a common misconception that opting for the EB-1A Premium Processing either increases your chances or ensures an approval. And in reality, it only works to expedite that I-140 petition processing time, and it is important to note that it does not shorten the I-45 processing time or change your priority date. Now, what's a priority date? So your priority date is the date that USCIS receives your I-140 petition. You know that your priority date is current because each month the Department of State releases a visa bulletin that displays the final action dates according to each green card category and the applicant's nationality. Now, when your priority date matches the final action date in your country and category, your date will be considered current. So for a lot of nationals, depending on the category, you might be current, but for nationals, specifically of mainland China and India, sometimes they are not current. Now, what should I do once my priority date becomes current? So this depends on whether you plan to adjust your status or go through consular processing. So if you are adjusting your status while in the US, you can file for the I-45, that form I-45. If you are going through consular processing, you can make an appointment with the US consulate or embassy in your home country once NBC instructs you to do so. Now, if you're in the US, you might wonder, how long will it take to process that I-45? So your I-45, just like your I-140 petition, is processed at a local service center. So therefore, it is subject to how busy that particular center is. However, it generally has an average processing time of over a year. Now let's take a step back and talk about the requirements for the I-140. So how do you prove that you have membership in a distinguished organization? So you must submit the qualifications for membership in the organization or association, and it will be helpful if the individuals who choose members are considered experts in their fields nationally or internationally. Another question is, what type of published materials about my work will be accepted? So this means that a major media network or publication must have published material that names you for your work. Now, if you are an unnamed team member whose work was mentioned in a publication, then USCIS will put much less weight towards it. Another question is, how can I prove that I was a judge of work of my peers? So for this specific prong, you must show that you have sat on a panel of judges, led a workshop, or facilitated a discussion group at a national event to qualify. And you will also need to confirm that what your role was and how involved you were in the judgment of the work of your peers. Another question is, what kind of significant contributions are acceptable? So the contributions must be original and scholarly, artistic, business-related, or scientific. They need to do more than just prove that you were successful. They need to prove that you are in the top percentile in your field and that you are positively impacting your field. And because of this broad category, work with your immigration attorney to determine what qualifies you. Another question is, what will the USCIS accept as evidence for scholarly articles that I've actually written? So you need to have irrefutable evidence that you are the author of each article. These articles must also have been published in a scholarly or business journal that are nationally or internationally circulated in your field. Now, your articles may be less valuable if your field is one in which many people publish articles. Now, another question is, what if my petition is denied? So if you have had your EB-1A petition denied, then USCIS has disclosed the reasons for your denial in the decision notice. To avoid an unnecessary rejection or denial, try to avoid the following reasons. So mistakes on the petition, improperly filed fees, extensive criminal history or a past violation of immigration status, and overall lack of EB-1A qualifications. So most of these issues can be avoided if you take your time to discuss your eligibility with a qualified immigration attorney. Now, another question that we'll receive is on the terminology of rejection and denial. So is there a difference between a rejection and a denial? And the answer is yes. A rejection means that an issue caused your petition not to make it through the decision-making stage. And this is usually due to an incorrect fee payment, an outdated form, or a petition with missing pages or information. On the other hand, a denial means that your petition made it through the decision-making process and was denied by an evaluating officer based on the merits of the case. Now, can you appeal an I-140 denial? Yes. So you may appeal the denial through the Administrative Appeals Office, so the AAO. However, this is usually not the ideal case, as the appeal request could take a long time to process, and the AAO often decides to uphold the original decision rather than overturn it, and it is sometimes better to refile the case once you have stronger evidence. The best way to determine whether you should appeal a denial is to hire an immigration attorney to look over your case and see if there's anything that was overlooked that could be brought to light about your case. So another question is, what is a legal motion? And there are two types of motions that can be made here. So the first is a motion to reopen. A motion to reopen the case is meant for situations in which new evidence or facts can be presented which were not available at the time of filing the case that alter the case significantly enough to warrant requesting the original entity that evaluated your case to reopen it. And the second is a motion to reconsider. A motion to reconsider is appropriate for situations in which you and your attorney believe that the evaluating officer was wrong in his or her decision to deny your case. You must present an argument that shows how you meet the requirements from a legal perspective. And it is best to take this route with the guidance of a specialized immigration attorney. Another question is, what happens if I receive an RFE? So if USCIS believes that the documentation is lacking, it may issue a request for evidence, which is commonly referred to as an RFE. And if you receive this, you will have a limited window of opportunity to give a satisfactory response with additional evidence. The best way to handle an RFE is to have your attorney help you respond to it as soon as possible. So as promised, here's some bonus information that you may not know about. So here are the important notes regarding the letters of endorsement. So letters of endorsements from experts in your industry are highly important to your EB-1A visa application. These letters should not be the primary evidence to show that you have extraordinary ability, but only used to supplement your already strong evidence. So letters of endorsement from experts in the field are very helpful in explaining the importance of your accomplishments and contributions to the field. And it would help if you began to think about who you can reach out to for your letters of endorsement early in planning your EB-1A visa application. So I hope you found this video helpful. Subscribe if this content or information helps you in any way. Comment below if you want me to talk about something specific, and share this resource widely because you never know who needs answers to these questions. Additionally, if you have any specific questions about this video as they pertain to your unique circumstances, please schedule a consultation with us at the link below, and I'll see you in the next video.